Good morning and welcome to the Standing Committee on General Government. You have 15 minutes for your presentation, 5 for questions from all three parties. The time will be divided. Please state your name for the purposes of our recording, Hansard, and you can begin your presentation when you like.
Okay, great. Say my name. Barb Sukkau.
Good morning. I'm Jim Flood.
Good morning. My name is Peter Griesbach.
Thanks.
Okay. Good morning again. My name is Barb Sukkau, and I'm the chair of the Ontario Real Estate Association's Government Relations Committee. I want to thank you for the opportunity to present on Bill 173, the Mining Amendment Act 2009. Joining me today, Jim Flood, OREA's Director of Government Relations, and Peter Griesbach, one of our members who has been adversely affected by the current Mining Act. By way of introduction, the Ontario Real Estate Association is one of the province's largest trade associations with over 47,000 member real estate salespeople and brokers. OREA was founded in 1922 to organize real estate activities and develop common goals across the province. These goals include promoting higher industry standards and preserving private property rights. Let me begin by saying that OREA is generally supportive of Bill 173. In our opinion, Bill 173 makes important progress towards stronger, better defined property rights in our province. In particular, we are encouraged that Section 15 of Bill 173 withdraws all mining rights from Southern Ontario in areas where mineral rights are owned by the Crown but surface rights are held privately. As many of you know, Southern Ontario was the region of greatest contention between prospectors and property owners. Removing mining rights held privately on privately held land will stop the proliferation of confrontations between prospectors and property owners in the region. Additionally, we commend Minister Gravel for moving quickly after the bill's introduction to issue a mining rights withdrawal order for Southern Ontario. This timely withdrawal order avoided what would have been a rush by prospectors to stake out as many claims as possible in Southern Ontario as Bill 173 awaited passage. In the area of prospector certification, OREA is pleased to note that Bill 173 reaffirms mandatory licensing. This section also now requires that licensees take a prospectors awareness program as a condition of obtaining or renewing a prospecting license. We believe that an effective licensing and continuing education regime will ensure that prospectors have a minimum level of training and are aware of the mining rights and restrictions that flow from the Mining Act. To complement the mandatory prospector course, OREA recommends that the Ministry include a section that reviews the obligations that prospectors have to surface rights holders under the Mining Act and be required to carry appropriate liability insurance. In Northern Ontario, OREA believes that Bill 173 has, for the most part, found the right balance between ensuring a strong and vibrant mining industry and protecting the private property rights of Northern Ontario property owners. In particular, OREA supports Section 46, subsection 1 of the Act that requires prospectors to give notification of a claim to property owners within 60 days of making the application to record the claim. This requirement encourages ongoing dialogue between the prospector and the property owner, which will reduce confrontations and improve collaboration to ensure that damage to the property is limited during the initial exploration. OREA is also pleased to see the inclusion of map staking in Bill 173, a recommendation that OREA made during the most recent Mining Act review process. As you are no doubt aware, traditional methods of prospecting are often destructive and intrusive to private property. Map staking removes the need to cut down trees, knock down fences when a prospector stakes a claim. Although OREA commends the government for the aforementioned measures under Bill 173, we do have a few concerns with the legislation and regulation drafting process moving forward. First, OREA notes that the purpose of Bill 173, as set out in Section 2, does not mention or affirm the rights of surface rights owners. Therefore, we strongly recommend that Section 2 be amended to include wording that recognizes and affirms the rights of surface rights holders, as has been done for Aboriginal and treaty rights. Second, like most pieces of complex legislation, details on how specific measures contained in Bill 173 will be implemented have not yet been formulated. OREA therefore urges the Ministry of Northern Development and Mines to post all draft regulations on the Environmental Registry for comment by stakeholders. This will allow stakeholders to review and critique how the government envisions implementing specific amendments to the existing Mining Act. We look forward to reviewing these draft regulations and providing comments as necessary. Realtors know that if we take the time to get the new Mining Act right, it will save enormous amounts of resources in the future. OREA is also concerned about Section 12 of Bill 173, which amends the Restricted Lands section, or Section 29 of the existing Mining Act. OREA does support the current list of restricted lands that are covered under the legislation. However, we suggest that the list be expanded to designate farms as being restricted from mining claims. According to the 2006 census, 2,479 farms, encompassing a total area of 1 million acres of land, are located in Northern Ontario. OREA believes that the property rights of farm owners deserve the same level of protection that was initially granted under the original Mining Act and that are now afforded to other property owners under Section 29. OREA is also concerned about the arbitrary powers given to the Directors of Exploration pursuant to Section 78 in the proposed legislation. While the concept of exploration permitting is sound, there should be some avenue of appeal available for surface rights owners. Lastly, OREA is concerned about subsection 2 under the Restricted Lands section of Bill 173. In our opinion, subsection 2 creates a loophole for prospectors to stake out a claim and apply for permission to record the claim from the minister afterwards. OREA believes that this section may lull or confuse many Ontario property owners into believing that their land is restricted from prospecting. OREA strongly believes that lands listed under Section 29 should be completely off limits from staking until permission from the minister is given. Realtors urge the minister to clarify through regulations what specific circumstances subsection 2 can be used by a prospector to apply to the minister for approval for a previously staked claim. We look forward to reviewing the regulations for subsection 2 to ensure that there are not loopholes to circumvent the aim of creating a restricted lands list in the new Mining Act. Despite these shortcomings, OREA reaffirms its support of Bill 173 and the important steps towards strengthening private property rights it makes. However, the process is not yet complete. As the government drafts regulations to implement Bill 173, OREA urges it to continue to strengthen and define property rights as they relate to surface rights holders. Bill 173 is an excellent opportunity for all of our elected officials to stand up and commit themselves to supporting Ontarians' right to use, benefit from, and transfer their property. Thank you for the opportunity to present to the committee today, and we'd be happy to take any questions.
Thank you, Mr. Barrett.
Just a brief question. I think Mr. Hillier has some questions.